Hey guys, how's it going? Do you love the wonderful Christmas tree in the background? My mother decorated it. Isn't it beautiful? I think so. Okay. Um, you guys, welcome to my video. Good morning, good afternoon, good evening, whatever it is for y'all. I just wanted to follow up with y'all on the Texas lawsuit. I did a video about it before, except I didn't read it all the way through, and I read it all the way through, and I just wanted to touch base with y'all. Um, just kind of share what I know about it. All right. Um, all right. So the arguments for this lawsuit, at least the ones that I saw on the internet, I'm just gonna touch on three. One of them was, oh, we'll get it right going forward. You don't have to do a lawsuit. And another one was, oh, it's a catch-22. You can't do anything before the election. You can't do anything after the election. And then the other argument was, oh, there's no evidence. It's like, okay, well, get it right going forward. Well, no. As shown in this Texas lawsuit, it was by design to weaken and eliminate these safeguards for universally known potential for fraud and abuse of these absentee mail-in ballots. You think an increase in absentee ballots would be an increase in these established safeguards. That would just be common sense, right? Maybe just for you and me. I don't know. And those who say, oh, it's a catch-22, you can't do anything before, you can't do anything now. It's like, why do you think we can't do anything now? There was non-legislative modifications that had a material impact on the outcome of an election in swing states. So I think what argument they're trying to say is like, oh, well, y'all should have caught us before we did it. And it's like, oh, okay, so y'all are like into the Minority Report style policing, and that's coming from the Democrats. Okay. Again, these dots don't connect, but whatever. And then the other argument, there's no evidence. I think that's like legal jargon that they can put it on a headline. Oh, there's no evidence. And what they mean by evidence is like, oh, evidence that was like submitted in to a court, during a trial or whatever. Not the evidence like, oh, this is evidence, like they're saying, oh, the evidence is in here. We're just asking permission for you to like see it and for it to be presented in court. Oh, okay. But anyway, so let's get into the lawsuit. I'm going to try to be quick about this. We'll see how that goes. Okay. I first want to note that in the lawsuit, I don't know much about law language at all. It just is very not second nature to me, but just the language in and of itself, it just seemed really polite. It was very respectful of the court and at the time, and just saying like, oh, I know this is unprecedented, and I know things don't go this way, and like, but this and this, that, and the third, it explains, why, it is how it is. But basically, I can sum it up for you and say it's an unprecedented moment. And so the cause of action in this lawsuit, because lawsuits need a cause of action or something like that, is electing a president and a vice president is a joint or shared venture or enterprise of all the states combined by the power of the Constitution. And the plaintiff state was injured by flagrant disregard of non-legislative modifications of I'm jumbling myself up here. Okay. So the plaintiff state was injured by flagrant disregard of equal protections, meaning the one person, one vote, and due process. Okay. By means of okay, let me start. Okay. So the plaintiff state was injured by flagrant disregard of equal protection, one person, one vote, and due process by means of non-legislative modifications. All right, we're going to get into these non-legislative modifications, and they all really basically center around these absentee mail-in ballots with the intent of being a COVID precaution or regulation. However, yeah. So there's 4 defendant states. Let's start with Wisconsin. So they have it in their state law that, this is a quote, absentee voting is a privilege carefully regulated to prevent the potential for fraud and abuse. So they're very much aware of all that. And so they had voting in April, and then in June, they came up with a Wisconsin Safe Voting Plan of 2020. It had a budget of $6,324,567, and it in that, it's online in the links in the lawsuit, but I'm sure you can find it without the lawsuit. But it was basically to assist people with absentee voting, whether it be to like help them upload their the required photo ID, or with drop boxes and in-person voting, which you can do an absentee ballot and give it in person, which is like, what are we doing here? But anyway, and in that plan, it even says that there's like a lot of obstacles into getting a successful, legitimate, valid, legal absentee ballot. So they're aware of that, and it says they're aware of that in there. So, okay. So the Wisconsin Election Commission and the local election officials, they suggested that people mark themselves indefinitely confined in order for them to be able to get an absentee ballot. But it just so happens when you mark yourself indefinitely confined, you get to avoid the photo ID requirement and the signature requirements. So, oops. Okay, so in April and in October, the administrator of the Milwaukee Elections Commissions suggested or decided to cure absentee ballots. In the process of to cure a ballot or curing, I learned it in the lawsuit, is when you already applied for your absentee ballot, you got approved, you got sent one. And then you send it back, you filled it out and you send it back, but there's like something wrong with it, whether, for like the date, something's wrong with it. So the clerk is like, hey, this ballot, there's something wrong with it, it needs to be cured. I'm gonna send it to you. The voter cures it, fixes whatever needs to be fixed, and then sends the cured ballot back. So the administrator of Milwaukee Elections Commissions was just like, you know what? We're going to cure your ballot. You don't even got to worry about that, which is, again, eliminates all of these safeguards and signature verifications and all that. Okay, Michigan. So in Michigan in 2020, there was 57% of the total votes cast were by absentee ballot. Okay. All right, and that is 5 times the number of ballots requested in 2016. It's just, okay. All right, and so the Secretary of State announced that absentee ballot applications be sent to all 7.7 million registered voters. That was in May, the end of May. I don't know why, like, I don't know why. Okay, so in June, or I don't know why the purpose of that would be. It was like were you still locked? Was Wisconsin or was Michigan still locked down in end of May? Was there no end of sight of the lockdowns at the end of May? I don't know. Okay. So in June, she allowed a program where you can request an absentee ballot online. And when you do that, again, you bypass signature verifications and all that good stuff. Also in Michigan, the number of votes not tied to a registered voter but tabulated anyway is 392,310. By the way, Biden's margin of victory in the entire state of Michigan is 146,007 votes. However, in Wayne County, it's almost double. Biden's margin of victory is almost double that of the entire state. In Wayne County, his margin of victory was 322,925 votes. And I read that in that county, they ignored the written statement or stamp that is on the ballot envelope that was the proof of verification that the signature on the ballot matched the signature on the file. So on November 17th, it was 2 out of 2 deadlock to certify the election results. Later that day, they ended up certifying it, but the next day, the 2 Republicans rescinded their certification, saying that they do not believe the results should be certified until serious issues are solved. And they did that in an affidavit saying that they were like bullied and stuff, which, okay, Georgia. So in Georgia, there was a thing called the settlement. Its the official name is Compromise, Settlement, Agreement, and Release. And this mainly focused on changes in rejection requirements. And it also permitted early opening of ballots, which violates state statutory law. Okay. And this, so among other things of the settlement, it goes like, okay, a part of it was, so before the settlement, somebody would see a signature and be like, hey, this looks suspect, I'm going to put it in the suspect pile. Now with the settlement, it was, hey, you need a 2 to 3 majority review. So if I see a signature and I think it's suspect, I have to get 2 other people, and and 2 of the 3 of us have to agree that it's suspect. So if I think something's suspect, I get 2 other people, and they're like, no, we don't think it's suspect, then I can't put it in the suspect pile. Okay. I don't know, it seems like, I don't know, okay. On one hand, people can argue, oh, that's just more barriers or more safeguards. And it's like, yeah, the other way. Okay, anyway, in the settlement, there was also, it required state election officials to consider issuing guidance and training material from an expert retained by the Democratic Party of Georgia. Also to note, by the way, the settlement, this is a result from a friendly lawsuit from the Democratic Party of Georgia versus Raffensperger back in March 6th of 2020. Friendly lawsuit, I was like, what is a friendly lawsuit? What is that? And it basically just means like the result of a friendly lawsuit is something that both parties wanted, but one of us got to get sued, so we just gonna be friendly about it, I guess. I don't know. Okay, and also in Georgia, so the legislature, that happened, that was in March 6th. The legislature did not materialize the changes to statutory law, and there was no severability clause. I learned about a severability clause when I was reading about COVID in my Bexar County Judge Wolf's executive orders or whatever. He always included a severability clause. And so that's basically means like, if you got all this right, but you got this one little thing wrong, but you have a severability clause, you can just take out the little wrong thing. But if you don't have a severability clause and you got all this right, but one thing wrong, you got to take out the whole thing. So yeah, no severability clause with the settlement. And yeah, in Georgia, the rejection rate of the mailed-in ballots was 17 times more in 2016 than it was in 2020 during all this hysteria pandemic stuff. Okay, so now let's talk about Commonwealth of Pennsylvania. There was a guide to not separate ballots based on signature analysis, which is like, what are you going to separate ballots on? Like retinal analysis? You going to put my little retinal little barcode on there? Like, I don't get it. Okay. And that, again, that was the result of a friendly lawsuit. It was the League of Women Voters versus the Secretary of State. That happened September 11th. The League of Women Voters, I think, check the lawsuit, but if I remember correctly, it said that checking the signatures is like not a good way to go about it. And I'm like, okay. So anyway, and then the Secretary of State also said that the curing process instead of it being a whole process with the voter doing the curing. She was basically like, nah, we're gonna do the curing here, fix any mistakes for the voters. I don't even know if there was like a procedure to like let the voter know, or I don't know. Okay, and the poll watchers were blocked. And in December, the Republicans did a lot of work in Pennsylvania, and they came out with a report called the Ryan Report. And there were ballots with no mailed date. There were ballots that were returned on or before the mailed date. And there were ballots that were returned one day after the mailed date. So there's a lot of discrepancies there. They also extended the deadline 3 days after the election and the presumption to include non-postmarked ballots. That was in a lawsuit and actually went to the Pennsylvania Supreme Court, so that's not good. But still, aside from the not presumption of including the non-postmarked ballots, the ballots with returned on or before the mail date or returned one day after the mail date, that's discrepancy out the wazoo. Okay. All right, so those are like the facts of or in the lawsuit. There was a lot more facts, and they presented it a lot better in the lawsuit. If you want to read that, go for it. It's very informative. So yeah, and then people were asking, well, why the Supreme Court? Okay, well, I guess it's all about jurisdiction. I guess that's where any cases go. So with jurisdiction, it's all about like the place and the subject matter. And so for this suit, the place is the United States because it's state versus state, state v. state. And for the U.S., it's the Supreme Court, and when it's a state versus state, it's exclusively so to be handled by the Supreme Court, according to Article 3 of the Constitution, and also the subject matter. The subject matter is the Constitution, the constitutionality of all this. The Electors Clause was, violated if they pick their electors based on the certification based off all this. And the 14th Amendment, I think, is that due process? Okay. So yeah, the constitutionality of the equal protections and due process and all that. And then so the Supreme Court was like, oh, we don't have any standing. No, I would disagree, but it wouldn't mean much. Okay, so for the standing doctrine, there are 3 basic things. It says, number 1, if the court has standing, there's a cognizable injury to the plaintiffs, which in this case, it's the material impact on the outcome of the election. And another thing, okay, so, and then also in the lawsuit, it states it, so it says, oh, state of Texas is representing like all the voters, but they're like, oh, we're gonna add another thing to this cognizable injury to the plaintiffs because we're gonna be all detailed like that. The state is represented by the Senate, and when there is a Senate majority, when there's a tie in the Senate, the majority is weighted by the VP. The VP decides that shit. And even more so, it's even more dire of a situation in 2020, depending on the outcome of the runoff election in Georgia. So if Kelly Loeffler and Senate Perdue, win in Georgia, or if they lose, it'll be like completely equal, and it would be the VP would be the one deciding all that. And so whether you're Republican, Independent, or Democrat, if you're a Democrat, I don't know, I don't understand how you can feel represented by the Democratic Party, but whatever. But if you feel aggrieved and if you feel like all of this is done, like, they obviously don't care about your voice enough to be like, oh, I'm gonna do all of this shit to take your voice away. So if you're against all that, and if you're in Georgia, and if I were you, I would vote for Kelly Loeffler and Perdue for Senate. Early voting started today, So yeah, okay. So for standing, so cognizable injury to plaintiffs, which is this, it's represented by this. The state is represented by the Senate, which is affected by the VP, and there was a material impact on the outcome of the election. So there's that. Two is the causation. Is that all that was caused by the challenge conduct, the conduct or the facts that I just listed, which, yeah, it is. And the third thing about the standing doctrine is it redressable by the court? I think it is. Because basically in the lawsuit, they're basically just asked, like, just say, like, just like, yeah, just say, like, oh, okay, yeah, they didn't administer the election in a legal way. And the plaintiff state Texas is just basically asking the Supreme Court to be like, hey, y'all defendant states need to honor the electors clause and elect the electors in a lawful way, whatever you deem fit, you know, whichever procedure is that you elect your electors, but actually do it constitutionally. Cool, let's do it that way. So yeah. Okay. All right. So I thought it was a good lawsuit. I don't know why people were huffing and puffing over it. All you gotta do is just read it and you'll be like, oh, fuck. That's a lot of information. Anyway, so yeah, I just told you what I know about it. That's really all I know about it. I would love to know what y'all know about it and what y'all think, and like, where do y'all think we should go from here? Like, what's the next step? Okay. I guess this video is not going to get any shorter, but it will definitely get longer if I keep this up. Okay. You like the Santa? My grandpa gave it to me. He got it at a garage sale. You love garage sales. Okay. Anyway. Yeah. I hope to see y'all soon. Love y'all. Bye.